Allez.
Oui.
Bon après-midi aux distingués membres du comité. Je vous remercie.
Good afternoon to the distinguished committee members. Thank you for this opportunity to share the Canadian Civil Liberty Association's perspective on Bill C-63. The CCLA is a national independent non-governmental organization founded in 1964 with a mandate to defend and promote the civil liberties, human rights, and democratic freedoms of all people across Canada. At the heart of our mandate is the fight for strong protection of freedom of expression, privacy, and the principles of fundamental justice. The CCLA recognizes the importance of legislative initiatives to protect some of the most vulnerable members of our society from particularly harmful forms of online speech. In this sense, the CCLA recognizes that some of the specific obligations created by Part 1 of Bill C-63 for operators of regulated services are welcome. However, the current draft of the Online Harms Act also includes more general statutory obligations that need to be clarified and appropriately limited, failing which they will raise issues of freedom of expression and other matters. For example, the general duty to implement adequate measures to mitigate the risk that users of the service being exposed to harmful content is decidedly vague in scope. In the absence of adequate safeguards, operators are likely to attempt to comply with this imprecise obligation as efficiently and economically as possible. This could be done at the expense of users' freedom of expression, for example, through proactive content monitoring, which is not at this stage prohibited by the Act, or through content deletions based on non-transparent algorithmic analyses. The general duty imposed on operators to implement tools and processes to flag harmful content under Section 59 suffers from similar shortcomings, also likely to jeopardize freedom of expression. For example, the Act as drafted would allow operators to remove several categories of reported content without giving the author the opportunity to present his or her point of view. In fact, for several categories of content, the Act as drafted even implicitly allows operators to remove reported content without first determining whether it actually qualifies as harmful content. These issues can be mitigated through recommendations 1 to 3 of our written submissions. We suggest that operators be required to fulfill their statutory obligations without engaging in mass surveillance or unduly limiting their users' freedom of expression. We also recommend that the new Canadian Digital Security Commission be required to ensure on an annual basis that operators are indeed complying with their obligations in relation to users' rights. With regard to Parts 2 and 3 of the bill, the CCLA welcomes the recent announcement by the Minister of Justice that he wishes to separate them from the current process. In so doing, the Minister of Justice is acceding to a request made several months ago by the CCLA and several civil society organizations to ensure that this committee's study of Part 1 is not overshadowed by controversial changes to the Criminal Code and the Canadian Human Rights Act. The CCLA believes that Parts 2 and 3 of the bill should not be passed by Parliament. With regard to amendments to the Criminal Code, the new hate-motivated offence would irrationally increase the maximum penalty associated with any offence in Canada up to life imprisonment if the commission of such an offence is motivated by hate. This vast judicial discretion paves the way for disproportionate sentences, increased plea bargaining by innocent vulnerable defendants while limiting freedom of expression in Canada. The CCLA also opposes the new fear of a hate propaganda offence or a hate crime provision. Criminal law should be a means of holding individuals accountable for actions they have taken, but not for actions that others fear they may take in the future. Allowing a judge to limit the freedom and expression of individuals who are not even suspected or accused of committing a crime, let alone convicted, unreasonably and unjustifiably infringes on many charter rights. Finally, as for the suggested amendments to the Canadian Human Rights Act and Part 3 of the bill, they would be inappropriate and ineffective in addressing the issue of hate speech in our modern society. These amendments would flood human rights organizations already suffering from a chronic lack of resources. Thank you for your attention, and I'd be happy to answer any questions.